we are going to have a panel discussion, and that is going to be on the theme of anticipating the future and dealing in particular with the impact of legislation on the sector and on the services that are being provided. Our special guests, moving from left to right here as part of this panel, are Enver Solomon, Chief Executive of the Refugee Council. We have next to him Nick Herbert, Policy Researcher on Modern Slavery and Trafficking from the Salvation Army. Tatiana Granjardin, Head of Modern Slavery Policy Unit, Justice and Care and Centre for Social Justice. And joining us again from Migrant Help is Anna Ware, who you saw on the last panel. I will be asking the questions as part of this panel, and we will be talking about the impact of legislation. And just going to get my notes from behind here, which someone has helpfully put behind a pull-up. You can't resist the opportunity to tidy, but not being an expert in this field, this is one area where I am actually going to have to use notes. So I'm going to start off with a question for all of the panel. Everybody's mic'd up and ready to go. And I'm probably going to work around from my left, so Annie will be the first to answer this question. But just for context, as I'm sure you all know, between the Nationality and Borders Act, the Illegal Migration Bill and the Victims Bill, there has been a mountain of new legislation to contend with in both the trafficking and asylum spaces. We've invited experts from both fields as part of this panel to help us navigate through the details of some of this legislation. So, questions for the panel. The first question which I'm going to ask, which we first directed to Anna Ware and then going around the panel, is what impacts have we seen from the Nationality and Borders Act thus far? Starting with you, Anna.
So I think, actually, I'll refer to the presentation I recently did and perhaps touch on that first, really. But, the delivery on the service and, for example, what Shona was talking about and the impact that it's had on the particular individuals, the uncertainty, the not really understanding what's sort of necessarily going to happen, the ever-changing elements that are happening as part of the system. And I think, the impact on the individual's mental health, mental well-being, the accommodation and moving around is so, it's just very difficult. And I think, again, touching on the building resilience aspect, we're here to support those individuals, and they're going through such difficult situations in the UK, and how do we manage ourselves and manage them and look after them when they're kind of in such an uncertain place. And I think, I worry that that's just going to get worse and worse, I think.
It's that theme of living in limbo that we've been talking about, absolutely. Tatiana, what impacts have you seen that you'd like to speak about so far?
I unfortunately don't work directly with the survivors of human trafficking and slavery. I honestly think I wouldn't be able to do that. The people who do that on frontline work on a daily basis are heroes to me, and I really applaud them for doing that, especially in this very challenging environment. So I can only comment on the things that have come out from the reports and research that my unit has done. So the Nationalities and Borders Act, especially the modern slavery provisions, have come into force only on the 30th of January. So to be honest, we have not had yet enough time to see the real effect of it. And I am also quite disappointed, let's put it that way, that the government hasn't given it time to work and already introduced another piece of legislation on top of that piece of legislation, without actually yet giving it a chance to prove or not prove working. So the only quantitative stuff that we've seen was the drop in the positive, reasonable grounds decisions for victims of modern slavery, and I assume that obviously everyone is expert here, so don't need to explain what it is. But basically, at the initial stage, or before the change, when the survivors were identified and referred to the National Referral Mechanism, to the Home Office, the first decision, the reasonable grounds decision, we had about 90%, I think, positive decisions, which then meant that these people were entering the Salvation Army support and were protected from being removed from the UK. Now that number has dropped to something like 53%, I believe, so it's a huge, significant drop in just the first 3 months. Now, that could be an issue of bureaucracy, technicalities, not understanding the guidance, not understanding the training. So I assume the number will go up at some point. But the government has already been challenged in courts on that. And just today, they've published new guidance, which I am trying to get my head around it. But again, we can discuss it. There'll probably be another question. So again, we see obviously that fewer victims of trafficking and modern slavery are entering the support, and there are more decisions that are negative and are being challenged. So it's obviously a worrying development, but we need more time to see.
And Nick, what impact have you seen from the Nationality Borders Act thus far?
I mean, I think I just need to sort of echo what Tatiana said, and I think that real visible change that we've seen after implementation at the end of January is at that initial point of entry into the NRM, or rather not being able to enter in the NRM. And really just the gateway is closed a bit, and much fewer people who we think from our experience as a first responder being an organisation who can make those referrals into the NRM in the first place, is that these people on the 29th of January would almost certainly have received a positive, reasonable grounds decision. The indicators are there, you know, from experience, it seems quite clear to us that these people should be entering support, but as the big drop-off that we saw from sort of 90% to 50, 55% shows, a lot fewer people are going into the system for that support. But that doesn't mean that there's fewer people who need support. It's potentially pushing an issue away as opposed to really addressing it. And I think, you know, as Tatiana was saying, we're still coming to terms with the implementation of it. We're still learning. We're still trying to see what's happening. I think there's a lot of questions to be asked about where are these people going? Where are they? And really, how can we make sure that they don't completely drop off from support entirely? Because there is a fear with the Nationality and Borders Act and with the illegal migration bill that what it's doing is just pushing people underground. It's pushing people away from the support they need. It's pushing people away from authorities. It's pushing people away from justice. It's pushing people away from law enforcement. And that's going to harm their chances of recovery, of getting out of that cycle of exploitation. And it's also going to hamper the UK's ability to tackle the issue and tackle trafficking and tackle trafficking networks. But yeah, there's a lot to be seen.
There is, and thank you so much for that succinct appraisal of what's been going on. Enver, how about you? What would you add to that in terms of the impact of that particular act?
So, look, let's be clear about one thing. I remember when Priti Patel was Home Secretary and she was announcing the legislation, and she said very clearly in the House of Commons and in public statements that the intention of the Act was to stop channel crossings and to break the business model, in her words, of people smugglers. Well, I don't think the legislation has done either of those things, unless I've missed something in the news that you've all seen. But the numbers arriving and having to make dangerous journeys are still pretty much the same as last year, about 6-7% down, but the main arrivals last year were in July, August, and September. I see no evidence that the horrendous activity of people smuggling and those behind that pernicious, nasty business has been broken whatsoever. So on the face of it, the legislation so far has failed in its ultimate intended goal, which is how it was sold to the British public. And I think it's important to note that. But then I think it's also important to understand some of the really damaging things that this legislation has done. So it created a two-tier system, and the rather Orwellian-sounding Group 1 and Group 2 refugees, and it in effect differentiated, or rather discriminated, between mode of arrival. So if you come here having taken a dangerous journey, you're seen as a second-class type of refugee. If you come here through a so-called safe route, you're seen as a more favourable, shall we say, deserving type of refugee with particular rights and entitlements that you don't have under the legislation if you arrive having taken a dangerous journey. And remember, people take dangerous journeys through no fault of their own. It's a choice that refugees have always had to face. It's not as if they choose, and they certainly don't asylum shop from our experience of the Refugee Council in the way that government ministers claim. So what this legislation has done is it has entrenched a form of rather pernicious discrimination in legislation. And those that come here, having taken dangerous journeys, are subject to a system which has pushed them into greater limbo and uncertainty. If you actually look at the data, the numbers that have come that route under the Act that have been found to be inadmissible, i.e. that they're not allowed to make an asylum claim because of the way they arrived, actually the numbers are not in the majority because there hasn't been anywhere that the government has been able to remove them to. So to get a permanent inadmissibility status, there's had to be somewhere that people can be sent to. And the numbers that have been removed under the legislation are very, very low indeed. Instead, what it's resulted in is another backlog and people being left in that backlog, waiting a decision on inadmissibility, with the vast majority, as I say, being then moved into the asylum system. And I think my final point, and it's really important to recognise this, the government has now in effect paused this system of two-tier operations, recognising that the only way to clear the backlog in these cases, not the older cases, but the cases under the Act, is to pause it. And if you like, I think that is an admission by the government that the bill in itself created a system that wasn't workable, that wasn't viable, and that was causing a huge amount of human misery by leaving people in another state of limbo.
Thank you. Tatiana and Nick, because of the way that the questions are divided up, I'll come back to you after another couple of questions, but Enver, if it's okay, I'd like to stay with you for the next one. But if anybody else on the panel wants to jump in, and this is within your area of knowledge or expertise, or you just have an opinion, do feel free to jump in after Enver has finished speaking. And that also includes Anna, who is standing in for Dr. Olayinka on the panel, just so we know where we all are. But Enver, my next question is to be directed to you. Just less than 2 weeks ago, the Court of Appeals ruled that the Rwanda policy was unlawful, as there are substantial grounds for believing that there is a real risk that any person sent to Rwanda will be removed to their home country when in fact they have a good claim for asylum. What do you think we can expect in terms of next steps for any offshoring policy, and what would you say is the efficacy of these kind of policies as a whole?
I mean, let's first acknowledge the importance of that Rwanda judgment. I think it was really significant that the court ruled that Rwanda wasn't safe, that its asylum system wasn't fit for purpose, that its judicial oversight was not satisfactory, and I think that is a really significant judgment. What it means is that the government, and as we know, they're going to appeal to the Supreme Court. We'll have to wait to see what the Supreme Court rules. That's going to be later on in the autumn, but I think it's going to be more challenging for that Supreme Court to now overturn the Court of Appeal judgment, given the very clear determination that Rwanda was not safe and that its asylum system is not fit for purpose. I think it's also important to recognise here that this isn't an offshoring policy like Australia. It is a wholesale outsourcing of the asylum system. It's a bit like if the government decided that they were going to outsource all hip operations to France. So if anyone here needed a hip operation, they'd be sent to France and dealt with under the French health system. That is in effect what it is doing. It's saying that we are going to outsource the entirety of our asylum decision-making to another country that actually the Court of Appeal has now ruled doesn't have an asylum system that's fit for purpose. And that is a hugely significant shift in policy, not just in the UK, but globally as well. And I think it's really important that this policy is challenged, not just in the courts, but it is challenged universally. And the argument is made that this is an outsourcing policy, which does, as the UN has made very clear, drive a coach and horses through the spirit of the UN Convention on Refugees. So where will this land? Where will this leave everything? Well, the reality is that without a Rwanda agreement, there is no so-called third country that people will be able to remove to. So without a Rwanda agreement, the government's policy is really in serious trouble. We know that for the vast majority of people that come to the UK from countries like Syria, from Afghanistan, from Iran, from Sudan, and we know what's going on in those countries, it's very difficult to return people. Okay, there has been a returns deal with Albania, but the vast majority are not coming from Albania. And there's a whole question marks over the issues around trafficking in Albania, which I think is separate. But without a third country agreement, the government's policy is in serious trouble. And I fear that what it will result in is a system which is mired in further chaos, in further human misery, and is utterly unworkable.
Thank you. Does anybody have anything to add on that theme? No. So the next question I have, I think, is one that Enver or potentially Anna could answer. So I'm going to check with Anna. Are you happy to answer a question on the illegal migration bill? Mm-hmm. Right. So the question we have here is, we anticipate an attempt to pass the illegal migration bill before the summer recess, which is the 20th of July. As proposed, it would mean a fundamental change to the functioning of the UK asylum system. How can those in the asylum sector prepare for its passage? Anna, are you okay to speak to that?
Yeah, I mean, I think actually Tatiana and I were having a very brief chat when we first sat down and really said about how, we felt that it's a lot of the work is going to fall upon charities, and just the work that we all do is just so entirely crucial and important in supporting people through. And especially when there are changes and there's so much adapting that has to happen, whether it's the change in clients' needs all the time or how we might deliver things. And I think working in partnership, being more collaborative, sharing knowledge, I think I sense there's kind of an emerging sort of networks that are coming out a lot more kind of connections where people are talking and are kind of working together. And I think that makes the sector immensely strong. One of the unique things I think about working in the refugee and the modern day slavery sector is just the ever-changing nature of the needs of our clients and how desperate they often feel. It's been touched upon and mentioned throughout sort of today and the impact on staff. But I think it will come down to sort of charities working better in partnerships, networking a lot more, and trying to be adaptable as much as we can, which I think is always far easier said than actually done.
Thank you, Anna. And Enver, what do you anticipate will be the impact of this on the UK asylum system?
Yeah, well, look, let's not beat about the bush here. This legislation is a watershed moment for all of us, yeah? It absolutely rips up the UN Convention on Refugees. It basically says that if you come here and you haven't come through a so-called safe route, you're not welcome in the UK. I mean, let's name it for what it is, because I think it's really important to recognise what this legislation is. And it's really significant what this legislation is going to do, and it's going to have a huge impact. First of all, it's going to lead to a massive expansion in detention. And this is detention of unaccompanied children, where there's clear time limits at the moment, of families, of vulnerable women and of vulnerable men. The bill provides the power to the Secretary of State to lock up people simply for having to come here, having made a dangerous journey and arrive through so-called irregular routes. So that is the first thing that is really important to understand. The second thing, and this is through our own analysis at the Refugee Council, we did an impact analysis on the bill. I encourage you to look it up, it's on our website, is it's going to lead to up to 190,000 over the first 3 years of the bill, either in detention or in limbo in the community. It's not clear what support they're going to be able to access. They're going to be in limbo because without an agreement with Rwanda or returns agreements, where will the government send them to? So they're going to exist in a no man's land. And you talk to local authorities, you talk to people that work in the system, and the first thing that they say to you is, we're absolutely concerned that people are going to disappear. I mean, if you're an unaccompanied child and you come here under the bill, once you turn 18, you can be thrown out of the country. What do you do as a child if you're facing that? You disappear, you vanish, because that's an understandable response. You talk to directors of children's services, they're absolutely concerned about the safeguarding consequences for that, for people being trafficked, people being exploited, which is a huge concern to children's services right across the country. So you're going to have a system which I think is fundamentally unworkable, causing a huge amount of distress. Already at the Refugee Council, People we're working with are very fearful about Rwanda, fearful about what it could mean for them. We've seen young people self-harming as a consequence, causing huge anxiety and distress. So how, as a sector, do we respond to this? I think it's absolutely critical that we evidence what this bill does on a human level. So absolutely remaining focused on the face behind the case. The so important finding of the Wendy Williams review is always to see the face behind the case. What are we seeing is happening on a human level as a consequence of this legislation, and absolutely highlighting it collectively to each other, highlighting it to decision makers, to commissioners, forming alliances to demonstrate and to powerfully articulate what this bill is actually meaning on the ground, at the front line, in practice, and how it is impacting on people's lives. Because if we do that, I'm absolutely confident that the evidence will get out of the really nasty nature of this legislation and how it will have such a negative impact on individuals, a really negative impact on their well-being, on their mental health, and will have a negative impact on our communities, because who wants people to be forced into the margins of our communities, to be disappearing into the twilight zone, where they can be exploited through multiple ways, where they can disappear into cannabis farms and all the rest of it. No one wants that to happen. And actually, when you speak to MPs across the political spectrum, they recognise the real risks with this legislation. And I really believe that if we collectively highlight the consequences of this legislation, it can lead to the kind of change that will be much more beneficial to those that we're all concerned about.
Thank you very much, Enver and Anna. The next three questions deal with the intersections of migration and modern slavery, so they're primarily for Tatiana and Nick, but do both feel free to jump in, should you so desire. So beginning with Tatiana first. Toward the end of last year, we saw modern slavery removed from the remit of the minister responsible for safeguarding, and it now sits on the immigration brief. Clauses 22 to 26 of the illegal migration bill are also dedicated to modern slavery. Tatiana, what would you say are the implications of conflating the issues of migration and modern slavery?
Thank you so much for your question. Just to start, I'll probably start with the illegal migration bill. We kind of nicely left off the previous question. And it is being debated right now as we speak here in Parliament. So last week it was in the House of Lords where the Lords introduced many amendments and the government suffered quite a lot of defeat. But I fear that right now they're just throwing all those amendments out one by one, going back to kind of the initial original version of the bill. We've been working directly to try and amend the bill, in particular in regards to victims of modern slavery, who, as you've just mentioned, in the clauses 22 to 26 are included, which means that those who have come to the UK or were brought into the UK, let's put it like that, illegally and then forced into exploitation now will not be able to benefit from any support and protection. And we've worked to, again, try and amend this legislation closely with Lord Rundle, who passed his amendment last week. But again, it's very much happening as we speak. It is really, really concerning in terms of what it is going to do. And it is not so much conflation with migration and modern slavery. There is nothing wrong with migration. It is perfectly fine phenomenon. It's great. I'm a migrant myself, as you can tell. I come from Eastern Europe, from Moldova/Romania. Felt very unwelcome on the Brexit vote, so that's another kind of political topic and issue personally, so I can imagine what's happening now with asylum seekers as well as victims, but I've nowhere nearly gone into have suffered through what the people suffer in terms of traveling to the UK when they're seeking asylum or when they are being trafficked and exploited. So there's nothing wrong with migration. The problem comes where it is conflated with organized immigration, crime, and when victims, the blame and the onus is being put on the victims, and they're not seen as victims, they're actually then seen as the criminals, because we're basically, with the illegal migration bill, we're punishing them for entering the country illegally and forgetting that they were actually a victim of a serious crime, and they were exploited and forced into sex and labor and criminality. But what matters more is how they entered the country rather than the trauma and the abuse and the exploitation. So I think that's the real problem. And we've been on the journey. We had so much success in 2014 when actually we took and when I say we, it's collectively the third sector actually worked a lot, and I worked at a different charity at that time to lobby for modern slavery to be taken out of the remit of the migration minister at that time. And then we had a minister for slavery, believe it or not, and then it was the Minister for Safeguarding. So we've been on a, I think, successful journey. We were not happy at that time, we wanted more, but now, in hindsight, I'm actually thinking that those were the good times when the then Prime Minister introduced the Modern Slavery Act, and there were a lot of training, resources, the Salvation Army, obviously, the support they provide across the whole country with migrant help and other organizations being part of that contract to provide services to adult victims of slavery. So it's really disappointing, to say the least, and frustrating to see us going backwards and making such huge, significant steps backwards. And all it means is just we're basically penalizing victims instead of providing the support. And I fear that, yes, there will be more people going into that ether, disappearing, and they will either be forced to become criminals themselves because they will have to do something to get their living, or victims of exploitation, abuse, and other forms. And that is the great risk and danger after this legislation becomes an act, a bill becomes an act.
And we know that traffickers tell the people they exploit that if you come forward, if you go for support, you will not be believed, you will be punished for it. And unfortunately, this bill just verifies that. It verifies that tactic. It plays into the hands of traffickers in keeping people in positions of exploitation. So there's a very real fear in terms of it, again, keeping people underground, doing nothing to break that cycle of exploitation that people fall into.
Absolutely. Nick, do you have any other thoughts on that idea of the conflation of the two issues, which Tatiana's explained so beautifully? She's done a wonderful job of explaining the context and the history of that, but on a practical level, as somebody from the Salvation Army, what would you say might the implications of that conflation be?
Modern slavery is not an illegal immigration issue. It's not an immigration enforcement issue. It's a safeguarding issue. It needs to be seen as such. And this is a move that just sort of cements the journey that we've been on in the past few years with the Nationality and Borders Act, now the Illegal Migration Bill, and the changes in statutory guidance that we might talk about. I'm not sure. What a segue. What we do know is that there needs to be a firewall between immigration enforcement and safeguarding in that sort of modern slavery space. We know, for example, that in recent months and years, the duty to notify statistics are going up. And duty to notify statistics are the statistics that represent the people who have the option to enter into the NRM but choose not to. And what we do see is that those sort of numbers are much higher among immigration enforcement bodies. So people come forward for that support. They come forward, it may be UKVI, it may be whatever organisation you want. But because there's that initial instinctive thought that this is to do with immigration enforcement, people are choosing not to enter that support. And that may lead down the line to further re-trafficking, further harm, further vulnerabilities. So we can see that that sort of much bigger decision of just changing remit, and it happens all the time in politics. Actually, when you follow it down, it does have very real consequences in the day-to-day running of the NRM and in the day-to-day choices that people are making when it comes to entering support or choosing not to enter that support.
Great, thank you. So sticking with you, Nick, for the next question, what are your thoughts about the revised modern slavery guidance and the impact on clients and sector organisations?
Tatiana said we're still sort of getting our head around it, so this sort of came out
It was
yesterday.
published
For that reason.
So thank you for the question. So the guidance, for people who don't know, at the end of January, there became an onus on those coming forward for support for those referrals to include objective evidence in those referrals. There's a list of things that they can include. It can include testimonies from medical experts, law enforcement, whatever it may be. Unfortunately, in practice, that's not very viable. You don't come forward for support with a signed receipt from your exploiter saying, I trafficked this person, please let them enter support. Often, people come forward with nothing. They're lucky if they have clothes sometimes. And then to ask them to present all this evidence just isn't practical. It's not workable. And it puts a much bigger onus on them, and also a much bigger onus on the first responder organisations, who suddenly have to act as a caseworker as well. This was challenged in court. The government sort of published new guidance on it yesterday. And it does seem from sort of first reading that has softened a bit. There is no longer that sort of concrete expectation for that objective evidence, but it is still sort of alluded to. And it does seem, therefore, that the real change is in how the decision is made as opposed to how that referral is put forward in the first place. We are all, as organisations in the sector, going to have to monitor that, as we have done for the changes in the past few months. I think what it does show is a very real need for there to be real consultation, proper and meaningful, at this policy decision-making level. I don't think there would have been a single first responder organisation or organisation in the sector who would have agreed with this idea of putting objective evidence in that initial reasonable grounds decision. And you do think about the thousands of decisions that have been made since the end of January and the people who may have missed out on support of that. And now we've got to July and we're openly admitting that, okay, this decision didn't work. And you do think if there was proper and meaningful consultation, then perhaps we could have avoided that issue in the first place. And I do think, as Enver was saying, you need to think about the face behind the case. And you need to make sure, and we all need to make sure as organisations, that when we are pushing policy change, we're also pushing for that consultation as well beforehand to make sure that it does involve proper consideration of the people it's affecting and, of course, inclusion of the people it's affecting.
Just to touch on that as well, and I think it's the trickle-down effect of some of these, I suppose, decisions and things as well, because certainly when all of that came out, we are also a first responder, and our NRM team just couldn't cope with the extra evidence provided, with the amount of support that we needed to provide. And this is not a funded element. You know, this is not a funded role. You don't get paid to do it. This is a charitable thing. So we've had to increase our NRM team just to be able to take all the referrals, because we don't want anybody to fall through the gap. And it's so much more work now to support these individuals. But just sort of the trickle-down effect on charities and us as a sector with some of these things that sort of happen is, it can definitely impact us all. So I think that's, one of the big factors, isn't it?
Yeah.
But I also think that the change that they've made is also opens it up for interpretation. So it's how the question I have is how the decision makers are trained. The guidance itself is there, but how do they interpret it? How are they trained, especially if things are moving and changing every 3 to 4 months? That's why I think we have very different quality in terms of decision making as well, because I hear that sometimes it could be the same case in terms of case of exploitation, a few victims from the same cohort, but one will get a positive decision and another will get a negative decision, and it's sometimes down to how the form was filled in or potentially the decision maker at the other end. So I think I think at the end of the day, it is the people who suffer, the potential victims who are there waiting to know whether they are going to access support or not. So there is, as Nick said, there is a real question in terms of what's going to happen to the people, what is already happening to those people who are getting negative decisions. And we are talking about thousands. So again, while we're take time to sort out the guidance and train the decision makers. We're talking about human beings and people behind it.
Yeah, I think people get very set in their ways at work, and when you're changing guidance every few months, understandably, it's quite hard to keep up with that. I got thrown when our coffee machine was moved in the office, let alone a sort of fundamental change in policy of how you do your work. Yeah. And, you know, it is a fundamental change of how these people have to operate in their daily job, and it's a very important job. You are deciding whether this person should receive support through the NRM or not. It's already highly pressured. And I think keeping up with these changes, I think, is really showing in the lack of consistency in the decisions that we're seeing.
Brilliantly explained. And in terms of the day-to-day realities of the people responding and trying to get through the system, plus those in charge of administering it, you've really got across what some of those challenges are. I will ask one more question, again aimed at Tatiana and Nick. I'll give the other two panellists the opportunity to say anything that they think we might have missed, so do have a little think about that, and then we're going to have 10 minutes of Q&A. But the last question I actually have written down here that I'd like to ask Tatiana and Nick, probably starting, I think, with Tatiana. The Home Office have advised that they're close to confirming a new independent anti-slavery commissioner, given that the post has been vacant since April 2022, since Honourable Dame Sarah Thornton was in post. What do you think are the priorities, or should be the priorities, for the new commissioner once in post?
Well, I have to state there is a bit of conflict of interest because I worked for the first independent anti-slavery commissioner, so I will probably be, in my thinking, is impacted by his priorities when I worked in his office with Kevin Highland. So it's hard for me to get myself probably out of that space. But yeah, we haven't had a commissioner for over a year now, and I'm hoping the appointment is imminent, and we're told that it is at an advanced stage. So hopefully it's going to be soon. From my point of view and experience, again, in working in the office of the Independent Anti-Slavery Commissioner, I think the Commissioner has certain powers that the legislation has given him or her to promote best practice in identification, detection, and prosecution of cases. There are certain authorities, public authorities, that have a duty to cooperate with the Commission. I think the Commission has to drive that and kind of national response to modern slavery. And I think where we haven't really made much progress is prosecutions and convictions. I really think, and through our research that we've done, since 2015, since the Modern Slavery Act was introduced, we have not made much progress on the number of prosecutions and convictions. It still remains very low. So, for example, last year, there were only about 194 convictions under the Modern Slavery Act made on an all-offence basis, which means that modern slavery wasn't necessarily the principal offence, but there were other offences, and modern slavery came secondary. So when modern slavery came first, it's a primary, it's only 43. And the numbers have been pretty stable since 2015. What happened with law enforcement activity? It skyrocketed. We have over 10,000 crimes recorded, modern slavery crime recorded by the police, because there is a duty to record almost every single NRM, especially every single reasonable grounds decision, for sure, as a crime. There are over 3,000 and 3,500 live police investigations at the moment across England and Wales. But the charging rate is only 2.3%. So the attrition rate is huge. The number drops significantly. So if you think there are so many, potentially 3,000 convictions, or could be even more, but we only see 200. So I think that's the area where the Commissioner could really make a difference. And I know Dame Sarah Thornton has done a lot, and I think that's where the law enforcement is one of big issues. Prosecution, judges, sentencing, all of this comes under this law enforcement heading, I think, because, again, there is much more that we need to do. to turn that kind of modern slavery from a low risk, high reward crime to kind of the other way, high risk and low reward. Because if we're not going to go after the criminals, we will only have more and more victims, as we see. But we really need to focus on that. I also think another priority should be prevention, and I don't think it had enough attention in the recent years. We've been focused a lot on reforming and transforming NRM, new legislation especially, but we're not really thinking about prevention. Just think, 1 in 5 of those who access the NRM are British children. 1 in 5. It is a big number. What are we doing to prevent those children from falling victims to criminal exploitation, most of them criminal exploitation and sexual exploitation? And they're not going anywhere. These are British nationals. So prevention should be a key focus, I think, for British nationals, but also prevention in terms of tackling root causes abroad. I also think that the Commissioner has a strong convening power, so partnership is key. And especially partnership across sectors, not just one particular sector. We're not in a bubble, modern slavery. Here we are today talking about asylum and modern slavery issues that are linked together. So it's important to link the third sector across, but also obviously partnership with statutory authorities, but also if you think, even cross-departmental partnership. Home Office is probably obviously the leading department, but there is so much more the others need to be doing. And the last but not the least, I think data and evidence is still something that is missing. We've got a lot of research and development in terms of research, which is great, but the actual data on slavery, all we have is the NRM figures, and this is not good enough. It's only the tip of the iceberg. We really need to get a grip on data and what we know about this issue to be able to fight it accordingly. So these are my 4, but probably 5 and 4.
Nick, anything to add on the priorities of the Anti-Slavery Commissioner?
I think on the data and evidence point, there is a great need to see beyond those NRM figures and see what's happening to the people who are yet to enter support, what's actually happening to those who are unable to enter support or choose not to enter support. So there's definitely a big gap there. And I also think data and evidence in terms of the implementation on the illegal migration bill, when it passes, and also the ongoing implementation of the Nationality and Borders Act, and just really seeing what the impacts of these are and making sure that any change to these are led by data and evidence. I think there's a very difficult tightrope to walk as the Independent Anti-Slavery Commissioner in that sort of independent role. You're being pulled one way by the Home Office, you're being pulled one way by the sector, and I think it's a really difficult role to navigate, and I think our previous commissioners have done that role incredibly admirably. And I think just making sure that level of independence is sort of maintained and making sure that they hold both government and sector to account and making sure that we're doing things to the best of our ability.
Great, thank you very much. Enver, is there anything that you'd like to speak to from those last 3 questions, or conversely anything you think is relevant that we may not have touched on, just quickly?
No, I think let's open it up and hear comments from others.
Let's open it up in here. We have a question towards the back. So the Migrant Help staff will be bringing the microphones over. We've got about 10 minutes before our keynote speech in which to ask questions of our very knowledgeable and esteemed panel I've learnt so much from. So, Amelia, question.
Thank you. What changes, if any, do you think a Labour government would bring?
Can I use that as a moment to promote an event that we are organising next week? In my role, I'm organising with Jess Phillips, MP, who is a shadow minister for domestic abuse and safeguarding. It will be live streamed. It's 18th July, 2 to 3 p.m. on our YouTube. When I say our Centre for Social Justice YouTube account and Twitter, she will be speaking about what's next in the fight against modern slavery, so kind of the next decade in her vision as a shadow safeguarding minister. She also has frontline experience. Prior to becoming an MP, she worked in one of the subcontractors and provided support to victims of slavery. So I'm really excited that she's agreed to come and speak at our event. So let's see what she's got to say, but we also need to acknowledge the difficulty that the Labour Party is currently in politically in the run-up to the election, so we may not hear as much as maybe we would like to in the next year, because obviously there are probably, the whole result is at stake, especially how political the small boats issue in the legal migration bill has been. So we just need, I guess, to be understanding, give time and see where things will go. To be honest, I do not expect that if Labour comes into government, that they will next day just suddenly say no more illegal migration bill or no more. We need to understand that it will take time for any changes to happen, even if the next government is going to be the Labour government. So I'm hopeful that maybe there will be some change, but again, we're yet to see. I don't think anyone knows what's going to happen, A, on the election, and B, how they will behave. I don't think they've commented on migration in particular. I don't know, Anva, maybe on asylum you've heard more. Let's see. I think it's a difficult question to answer.
Yeah, well, I mean, they've spoken out against Rwanda, so I don't think they'll go ahead with Rwanda. I don't think it will be their dream, like the current Home Secretary's dream, as she said, to see a flight take off to Rwanda, which is good. And I think they will absolutely want to look at the asylum decision-making process to ensure there isn't a backlog, to ensure there's more effective upfront triaging, better quality decision-making, and I no doubt they'll look at returns as well. I think they will seek to try and get a deal with the French as quickly as possible. I think they see that as a solution to channel crossings rather than passing legislation which effectively extinguishes the right to seek asylum in the UK. And I think there'll be a much more of a focus on enforcement against criminal gangs. There's been a lot of emphasis on that from Michelle, Home Secretary. So I think you will see a shift in policy. It may not be a radical shift to begin with, but I certainly think that it will be more of a kind of technocratic approach and perhaps less of a political, rhetorical, grandstanding approach.
Do we have any more questions from the floor? Yes, we have one there. Thank you. Just bringing the mic over.
Hi, thank you. So last Thursday, the Children's Commissioner put out a statement regarding the illegal migration bill. And one key highlight that stood out was the part around unaccompanied asylum-seeking young people and children who are now experiencing Coventry. Some have been trafficked, etc. And the bill states that they're under the care of the local authority, unaccompanied US young people. But with the new bill, it could be under the care of the Home Office, which is at the hotels, and there's huge significant safeguarding concerns around that. I guess the question is, what are your thoughts on that, and how do we look at getting around that, or lobbying, or ensuring that doesn't happen?
Yeah, so I think what the bill does is it gives the power for children, unaccompanied children, to be accommodated at the direction of the Home Secretary. So what that will mean is that when children are placed in hotels, unaccompanied children are placed in hotels, the duties under the Children Act for those children will still remain with the local authority in that area, but the Home Secretary will have the power to accommodate them in that hotel. So it's something that we've very clearly said that we don't think is the right approach, and we think the paramountcy of the Children's Act is absolutely vital. But I think it is important to understand that doesn't mean that children will not still be taken into the care of local authorities and be placed in a local authority care placement under the Children's Act. It simply means at the moment, the nature of the hotels that unaccompanied children are placed in is they're in a kind of legal limbo, because the authority for placing them there hasn't been under the local authority. The Home Office has been doing it, and what this bill simply does is it provides the legal cover, if you like, for the Home Secretary to place them in that accommodation, even though oversight under the Children's Act will still sit with the local authority. So I think it's really important in relation to unaccompanied children to be very clear that they shouldn't be removed when they turn 18, that how that will damage them, and to present the very clear evidence that that will have, if you're finding it through practice, and the way it's impacting on those unaccompanied children if they're facing removal when they turn 18. And I think it's important to point out if Children Act provisions are not being applied, or if they're falling through the gaps of Children Act provisions, to draw attention to that as well, because I think the fact that unaccompanied children are in scope of the legislation is an absolutely serious concern, and there's clearly tensions, more than tensions, there's clearly contradictions between the legislation is interfacing with the Children's Act that has been identified by Directors of Children's Services as well.
Thank you. I think we have time potentially for either one more question or for anybody else on the panel to speak to that question. Is anybody? No. So I think we have one more question from down here, and then we'll have to move on. So Mike's just coming over, and we've got 5 minutes to go.
Hi all, Robin Phillips from the Human Trafficking Foundation. Just one tiny point of clarification, that the modern slavery is still under the Minister for Safeguarding, but it's the so-called abuse of modern slavery that's under the Minister for Immigration. But my question is hopefully to pour a little bit of hope and optimism into towards the end of the conference. And I would like to know from each of you what one change, whether that's policy, whether that's legislation, whether that's something operational, you would implement for a more positive future. Great question, thank you. Who would like to go first?
Anna's happy to go first.
Yeah. I probably would say that because Arjun and the LEAP are part of my team, but I think for me it would certainly be hearing more voices when it comes to decision makers. I know that, for example, the Scottish Government liaised with some of our LEAP members when they were setting their strategy, and that was a really powerful relationship in a sense of the LEAPs got to share their voice around what some of the plans were that they were doing. And I think, if we can get decision makers to kind of hear the voices of the people that we are looking after, I think that will make a really huge difference. And that would probably be the one thing. It would be sharing those stories, having that space, and making sure that, people were listening.
Tatiana or Nick? Nick,
do you want to go first?
She's looking at you.
I think a really big one is the points we've raised on that sort of initial entry point into the NRM and the difficulties people face in entering support in the first place. So I think that whole process and positioning needs to be sort of properly looked at and scrutinised, and hopefully just made so much easier for potential victims to get the support they need. And that includes proper legal advice, that includes sort of support whilst they're making this decision, which is a huge decision to make, and really just sort of making that difficult time as easy as possible for the people who go through it.
Well, I can think of at least 5 things if I was Home Secretary. First of all, I'd repeal the legislation that's about to be passed. I would ensure we upheld the right to asylum. I would ensure that there was good quality decision making, good quality upfront triaging, that people are housed in a dignified way in the community, that they're allowed to work, that we have a proper national integration strategy for refugees, that we don't try and trip them up when they get refugee status, and there's consistent integration support. And I think most importantly, I would take the politics out of it. I would detoxify it, and I would change the language to be a language which is one that recognises individuals as fellow human beings, that recognises the importance of treating them with compassion and dignity, and the importance of upholding the absolutely core principle of giving people a fair hearing and not assuming them to be guilty of some kind of offence by simply having to move and seek protection through no fault of their own.
I think one thing, if I may add, because Anva's put it so eloquently in terms of asylum, I would say all of these things apply to slavery. But I guess one thing that I would really like to see is also the right to work. And I think we all know, both for victims of slavery and asylum seekers, that would change. It was going to be a sea change in terms of how people feel integrated in our society, the impact on our communities mentioned before. That would probably one of the things that I would really like to see. And I think it would just change the recovery journey significantly. But let's continue pushing for it, I guess.
Absolutely. Could everybody please join me in thanking the panel, Enver Solomon, Nick Herbert, Tatiana Grandjarden, and Anna Ware, standing in for Dr. Ollie and Kaluas. So double applause for Anna, and give her a round of applause.